Let's take a look at complaint procedures for harassment from an employment law perspective. Employers should establish, communicate, and enforce policies prohibiting harassment. Although failure to adapt policy is not by itself a violation of the law, a policy is basic to preventing harassment. Employers will generally not be able to show that reasonable care to prevent harassment was exercised and establish the affirmative defense in the absence of a formal policy. Real policies have more than a paper existence. They must be communicated, reiterated, adhered to, and enforced. Harassment policies should be included in employee handbooks, made available in multiple languages when necessary, posted in visible areas, discussed when orienting new employees, and made the subject of training. The efficacy of training in the prevention of harassment is open to question. When performed appropriately, training can make employees more aware of the conduct expected of them and what to do if they're confronted with harassment. In recognition of limitations of conventional harassment training and of the wider problem of workplace bullying, there's an increasing interest in workplace civility training. Such training, which typically incorporates interpersonal, conflict resolution, and supervisory skills, has the virtue of focusing on what employees should do when interacting with one another rather than what they should not do. Employers should provide training regarding prevention of harassment and discrimination more generally. This training needs to be geared towards the particular employee audience and part of a larger set of preventative measures. An adequate policy must unequivocally inform all employees that harassment is prohibited by company policy and the law and will not be tolerated. Concrete examples of harassment can be helpful, provided it's made clear that no listing of harassing conduct is exhaustive. The policy should clearly state that it applies to electronic communications, including offensive content conveyed by email, text messages, or social media site posts. Employees should also be alerted that harassment, based on other protected class characteristics such as race and national origin, is prohibited by company policy and is illegal. Employees must be told how to report harassment and be provided multiple accessible parties. Under no circumstances should an employee be required to report harassment to a supervisor or manager who is the alleged harasser. Harassment policy should require that supervisors and managers with knowledge of harassment, however gained, report it to appropriate people designated to handle investigations. It is vital that harassment policies provide strong and credible assurances that people reporting harassment will be protected from retaliation. Employees subjected to harassment are often doubly victimized, first by the harassment and then by retaliation for complaining. A complaint process cannot be effective if employees have reason to fear its use.